All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone in and outside the courtroom. Madam Court Officer, can you please call the case?
Morning, Your Honor. This is case file KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. Now I will kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor.
Thank you very much, Your Honor, and good morning, everyone. The prosecution team is represented today by Alex Whiting, Deputy Specialist Prosecutor, myself, Cezary Michalczuk, SPO Prosecutor, Silvia Diascoli, Associate Prosecutor, Filippo De Minicis, Associate Prosecutor, and also Aniko Boldog, Case and Evidence Management Assistant. Thank you.
Thank you, Mr. Prosecutor. Now I turn to the defense, please.
Good morning, Your Honor. My name is Julius von Bonnet. I'm the defense counsel of Salih Mustafa. Mr. Salih Mustafa will not be present today. He has confirmed that in a written statement. So I'm the only one today. Thank you very much.
Thank you, Mr. von Bonnet. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 26 January, I scheduled the fourth status conference for this case. My objective today is to review the status of the case and start preparing the transmission of the case to the trial panel. I see that no written submissions were filed by either of the parties. I will ask the parties for their submissions in turn, according to the scheduling order, first on disclosure, then on investigations, then on points of agreements on matters of law and facts, and finally, on the next procedural steps. As usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information, so we can go into private or closed session. However, before we start with this first item on the agenda, I would like to issue an order for submissions to both parties. I remind the parties that during the third status conference on 14 December 2020, a part of the hearing was in closed session at the request of the defense. In order to be as transparent as possible to the public, I would like to ask the parties for joint written submissions by Monday, 15 February 2021, on a lesser redacted version of the transcript of the third status conference. And I thank the parties in advance for their joint written submissions. Let me now move to the first topic on the agenda, namely whether the SPO has completed disclosure of evidentiary material, including exculpatory evidence, and if not, when and which material remains to be disclosed, under what rule, and when the SPO will disclose such material. I also invite the prosecutor to indicate whether the SPO intends to add evidence under Rule 102.2 of the rules. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. With your kind permission, I would like, before we move on to the disclosure points, I would like to make just a few very brief preliminary remarks on behalf of the prosecution. I would like to reiterate the general position of the prosecution regarding the course and pace of this pretrial process. As the disclosure has now been largely completed and it's now gearing toward its end, it is the SPO's position and intention to finalize the pretrial phase of the proceedings already in February and to move to the trial phase of the case as soon as possible after the filing of the pretrial brief and Rule 95, paragraph 4 material. As per our position indicated already during the third status conference, these submissions will be filed on the 15th of February. Having said that, we believe that we should all strive for commencing the trial as early as March 2021. On disclosure, I would give the floor to my colleague, Prosecutor Silvia D'Ascoli.
Thank you. Good morning, Your Honors, and everyone in the courtroom. Yes, I will be addressing the first point, the first item on today's agenda on disclosure, and detail what has been done and what remains to be done. Well, at the outset, the SPO can say that the disclosure by the prosecution is now largely completed and will be finalized in approximately 2 weeks, that is by the 15th of February. I will now give the specific details regarding the disclosure process rule by rule. I will first address disclosures pursuant to Rule 102.1b. I will then move to any additions pursuant to Rule 102.2, and finally I will conclude with the status of the exculpatory evidence. Your Honor, as already reported in the previous status conference, the SPO has largely completed the disclosure of its evidentiary material pursuant to Rule 102.1a and b in the past months, between October and December 2020, in compliance with the timeline set out in the framework decision. In addition to that, last week, on the 29th of January 2021, the SPO disclosed one additional item pursuant to Rule 102.1b. This disclosure 30 in legal workflow, was the result of the final assessment conducted on the items seized from Mr. Mustafa. Further, the SPO may add one witness to its witness list. This witness was recently interviewed by the SPO, and we are now in the process of assessing his evidence. If the witness will be added to the list of evidentiary material that the SPO seeks to rely on, this evidence will be disclosed to the defense by the 15th of February as well, together or even a little bit earlier compared to the filing of the pretrial brief. There will likely be an additional disclosure pursuant to Rule 102.1b. It will be a discrete disclosure of involving just a few items. And this will be actually the result of the review process of the evidentiary material that we are conducting in light of the drafting of the pretrial brief. At the end of the process, there might be, in fact, a handful of items to be disclosed pursuant to Rule 102.1b. We have identified the 2 so far, but there could be a little bit more, like a handful, I believe. And just to give you an idea of the nature of these items, it will likely be some maps, which are always useful to have, and what we call near duplicates. These would be copies of items already disclosed by defense, for example, photo lineups or prior statements, which, however, we found also in different layouts in the collection of evidence. And so just for the sake of completeness, we will likely disclose those items as well. In any case, this whole review will be completed by the 15th of February, and this discrete additional disclosure, if any, will be also provided to the defense counsel by the 15th of February, slightly before or together with the filing of the pretrial brief. Second, I'll move to the process concerning the Rule 102.2, so relevant material and evidence. This process is also concluded. The relevant list was disclosed to defense on the 1st of December 2020. Your Honor is asking whether there will be any additions to that. Yes, there will be. Again, just a handful. We've counted a total of 12 items which will be added to the list of material relevant pursuant to Rule 102.2. These items range from recent SPO interviews which were recently processed into our system, or criminal background checks which as well were recently processed into our system. This will be done by way of a filing supplementing the list filed on the 1st of December 2020, and again it will be done by the 15th of February in conjunction with the filing of the pretrial brief and the other Rule 95.4 materials. Now, some of these items under Rule 102.2 of the rules will also be disclosed as exculpatory evidence to the defense pursuant to Rule 103. And this brings me to my last point, addressing the status of the exculpatory evidence and the disclosures thereof. Your Honors, disclosure of the exculpatory evidence, of course, is an ongoing process, and the prosecution has been complying with its obligation in this regard from the very outset. We have disclosed already the bulk of the exculpatory material in this case in the past month, and we will disclose further exculpatory evidence together with the pretrial brief. We will also continue doing our due diligence reviews so that for the exculpatory process, so to ensure that by the beginning of the trial proceedings, the exculpatory disclosure searches will all be up to date. In terms of the latest exculpatory disclosures that the SPO made, the last one was done on the 18th of December 2020. This was disclosure 29 in legal workflow and consisted of a further 103 items. Now, about what's coming up, as indicated in December during the last status conference, the SPO needs to seize the pretrial judge in relation to some potentially exculpatory materials that need protective measures in the form of provisional reductions or withholding until the identity of certain witnesses is disclosed to defense. We are preparing this application, and we expect to file it together with the pretrial brief, if not slightly earlier than, again, the 15th of February. We expect that in February 2021, very likely in the same week of filing of the pretrial brief, there will be an additional residual batch of Rule 103 material which do not require reductions. So this will be in conjunction to the filings, to the application that we will be submitting to Your Honor. In sum, Your Honor, the Chamber can rest assured that by the end of February 2021, the SPO will have disclosed the main bulk of the exculpatory evidence in this case. And we remain available if Your Honor has any question.
Thank you, Madam Prosecutor. So I take it from your submissions that you will be done with disclosure by 15 February at the latest, that you will have seized me of any application by that date as well, and that you confirm that you still envisage to file your pretrial brief also on the 15th of February, correct?
Yes, Your Honor, that's correct.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Fonbonnet, did you experience any difficulties with the disclosure process? You have the floor.
Your Honor, the only difficulty that we have is that some of the disclosures are only in English, and especially of certain statements, they have not been translated into Albanian, and that makes it complicated. So that is the only difficulty that my client especially has with the disclosures.
Thank you, Mr. Fonbonnet. Madam Prosecutor, is there anything you want to add on this? Is there any translation that is pending, or does it refer to material that is not compulsory translated according to my previous decision? Madam Prosecutor.
Your Honor, all the material that has been disclosed pursuant to Rule 102.1a and b has been disclosed in both languages, English and Albanian. Now, whether the defense counsel is referring to exculpatory material or other material, I'm not sure, but we invite the defense counsel to reach to us with the specific ERN of the concerned material to the email address devoted to the correspondence between the parties so that we can assist with any specific answers or queries. But I can confirm that all of the material pursuant to the rules 1021A and B has been disclosed as it should have been in both languages.
Thank you, Madam Prosecutor. Mr. Fonbonnet, can you give some details about which statements you are talking about? Which category of disclosure does it refer to? Thank you.
There is one that comes to mind directly, but I'm not sure whether I should say that here in open session or closed session.
Madam Court Officer, can we move to private session for a couple of minutes?
Your Honors, we're in private session. Your Honor, we're back in open session.
Thank you, Madam Court Officer. I will now turn back to the prosecution for the second item in our agenda, which is the status of its ongoing investigation. I think you answered some of the question in your presentation on the disclosure of evidence, but nevertheless, can you still confirm that your pretrial brief will be filed on 15 February? And you also stated that you were going to seize me around mid-January 2021 in the last status conference. Can you just confirm that this is what your colleague just referred to, and I'm going to be seized of an application before 15th of February on this matter?
Yes, Your Honor, correct on all points. Let me now move on to the status of investigations. We already covered that point during the last status conference when I said that our office is conducting also investigations in other cases apart from this one, which simply means that there might be a situation where we find some evidence or information also of relevance to this particular case, and if so, there might be a need to add a couple of items to this investigation, and of course we will be then in need to comply with our disclosure obligation. But as I said before, and I'm going to also reiterate it now, whatever happens, we will swiftly comply with the disclosure obligations, and these additional things will not have any adverse impact on our trial readiness, as we indicated already. In relation to this particular case, with the witness interview that we conducted last week, I need to confirm that we don't have any outstanding investigative obligations. There remains some residual investigative activities, but they have marginal importance for this case, and again, they will not have any adverse impact on our trial readiness. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonbonnet, I would now like to ask you to provide an update about your investigations. In particular, have you concluded your investigations? And if not, when will you conclude them? And I also invite the defense to inform the court if it has the intention to give notice of an alibi or grounds excluding responsibility, pursuant to Rule 95.5, to make requests concerning unique investigative opportunities, pursuant to Rule 99.1. And I would finally ask the defense whether it intends to disclose evidence to the SPO, and if it so chooses, its estimated overall amount and type, and whether it intends to request protective measures prior to the disclosure of evidence, and if so, what kind of protective measures and for how many witnesses? Mr. Fonbonnet.
Thank you very much, Your Honor. I can say the following regarding the investigations. I think it will, first of all, the issue of an alibi. I think there will be an alibi provided by the defense, and there will be also witnesses for that. I expect to conclude the interviews with those witnesses within 2 months, approximately. Now, that is only regarding the alibi, because that has priority. And then I will give a notice at the appropriate moment when that is done. I am not sure whether there will be a need for protective measures or not. That goes, I simply cannot see or foresee how that goes with the particular witnesses. But when that occurs, obviously, I will seize the court in order to have those in place, or whether they should be in place for those witnesses. One issue that that we have probably not addressed yet, Your Honor, is the matter of points of law and points of fact that.
Sorry, we'll move
Oh, is that
to
the
this
next item?
topic after. So
Okay.
please,
Okay.
let's stick to the issue of investigations for the moment.
Okay, the investigations, as far as that is concerned, so there will be an alibi, that is for sure, and there will be other witnesses for sure on points of fact that are in the indictment, is the expectation. I cannot foresee how long that will take, but I only for the alibi witnesses, I need already about 2 months. We think that we can complete that within that time. Then there is a number of other types of witnesses that we are envisaging to interview, and I think that will take. Well, earlier on I said it would be 6 to 9 months, and I think before August that probably will have been completed. That is about the time that I think that we will have. It's not only witnesses, Your Honor, that we interview. We will also try to make some documentary evidence in the sense of reports and observations that we do on particular locations that we would like to present as evidence. That takes longer. It has not the priority at this time, simply because I think we need to move on with the things that we can move on with the quickest. So that is the status of the investigations as far as I think should do. Whether I make a request concerning unique investigative opportunity, so far I will not. Until today I have not. I'm uncertain whether I can foresee that. It depends a little bit whether there is any, but I doubt it, honestly. So that's the part of the investigation.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, do you want to say anything about the defense submissions? You have the floor.
Your Honor, I'd like to respond to that. First of all, we believe that this particular case is relatively straightforward and does not really require very intensive and investigations of a wider scope on the part of the defense. We believe that the indictment and the supporting material that we send very clearly delineates the parameters of the case, together with all the disclosed material to the defense that we have disclosed so far, presents for the defense this case in a very clear manner, and the scope and ambit of the case is very easily understood. It should not really trigger an extensive investigations and steps that could take months, as the defense has just stated. We believe that with what the defense already has, he could easily prepare his defense and prepare his case. The timelines that the defense has just provided, months, he indicated, for example, August as the time of completion of his investigations, is unacceptable for the prosecution. We also believe at the same time that such a lengthy period of time adversely impacts on the rights of the defendant to have an expeditious trial. Having said that, we understand the importance of limited investigations, and of course we understand the importance of the defense to present its witnesses for example, to prove the alibi or to confirm some defenses that are going to be put forward by the defense. However, as we said at the outset of this hearing, the prosecution will be trial ready just in a few weeks, and we don't believe that such an extensive time as the defense claims as necessary is justifiable. At the same time, I would like to underline that the defense has had already sufficient time to conduct those investigations. We had the first discussion about the commencement of investigations by the defense already a few months ago. Having said that, again, I would like to underline the position of the prosecution that we all should work on the commencement of the trial as early as March this year. Thank you.
Thank you, Mr. Prosecutor. Mr. Van Bonnet, regarding your investigations, do you need all the investigations you're referring to be completed before the beginning of the trial?
I'd say 2/3 of it should be completed before the trial, I think. The thing is that, Your Honor, if I can address a couple of issues. First of all, I think it's not up to the prosecution to make any argument about how the defense is about to go on or not. They have had ample time and they have had years of investigations, and we are not simply able to put up that so quick under the circumstances of these times as well. So let the defense do the defense work, and let the prosecution do the prosecution work. I think that's, if we stick to that, I think that's better. I do expect actually a longer list of witnesses than the prosecution has. And having said that, I think that is what takes the time. The priority of it is at the alibi. It is done now. I think we will probably have completed that within 2 months. And then it will take, I would not say an undetermined amount of time, but I mean, we're working on it in order to interview the witnesses and so on. Now, to get to your question, would that require that has to be completed before starting the trial? I would prefer so, honestly, because in the balance, what we will see is that some of the witnesses probably contradict what the witnesses of the prosecutions are saying. And the issue of points of law and points of facts, I think, if I brainstorm about it, and I can see that we will have quite large difficulties and disputes about it, because we'll get to that item in a minute. But in order to make the defense case, we will certainly disagree on certain facts as presented by the prosecution. In order to argue those facts, we want to rely on witnesses. And that takes time. It's as simple as that. And therefore, I do not want to get a trial in 2 separate speeds. Obviously, it is useful that at some point, when we have completed our investigation and we say, well, we're ready to go to trial, that would be the best moment to do that. Now, my assumption is that it will be August when we will have completed it. And we're depending also on some third-party factors in that perspective. Yeah, that's what I can say about it.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, do you want to add anything?
Just maybe one line in response to that. Well, first of all, my intention was not to sound offensive, and if I did actually sound offensive, I apologize, it was not my intention. My intention was simply to underline that the timelines indicated by the defense, bearing in mind our trial readiness, is simply not acceptable for the prosecution, and we have been conducting all outstanding issues, and we have been conducting investigative steps. We have been complying with our outstanding disclosure obligations, so that we were trial ready as quickly as possible for the interest of justice. And this is what I wanted to simply say.
Yeah.
Thank you, Your Honor.
Yeah, if I may add something, Your Honor. If the prosecution is concerned about the length of the trial regarding the detainment of my client, then they are free, of course, to make submissions in order to have my client released. It's as simple as that, but their position is constantly the same, and now it's going to be used as say, well, you know, your client is detained, let's move forward, let's move forward. I don't think so at all. We take the time that we need in order to have a balanced and correct and sound defense. That is the idea. And if there is any concern regarding the detainment of my client, then I look forward to different types of submissions of the prosecution until what they have done until now. Their position is very clear, and that's fine, but it should not be an argument in order to say, well, that's why we need to move forward now. Let that be up to the defense.
Thank you, Mr. Van Bonnet. Then let me now move to the next item in our agenda, which is the points of agreement on matters of law and facts. I would now like to ask the parties whether, since the last status conference, they have made any progress and reached an agreement regarding the submission of points of agreement on law and or facts, pursuant to Rules 95.3 and 156 of the rules, and whether and when the parties expect to be able to identify a list of issues subject to dispute and one with issues not subject to dispute. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. I would address both points jointly. As we indicated during the last status conference, the prosecution prepared a comprehensive document detailing all the points that we believe could be subject to agreement or disagreement, but we prepared the document in a way that would allow both parties and, of course, Your Honor, to understand where we stand when it comes to all the points that we believe are relevant. So in this regard, to be very precise, on the 21st of January, we submitted to the defense a table of our proposals. I have this table with me, where we, in a detailed fashion, presented to the defense certain facts, first of all relating to the accused, certain facts relating to the Kosovo Liberation Army, certain facts relating to the context of this case, facts relating to the alleged crimes, and also facts relating to other miscellaneous matters. So, as I said, we sent this table to the defense. Later on, I had a conversation with my learned colleague on the 25th of January. I also sent an email on the 29th of January asking whether the defense could come up with a written counter-proposal, written position on our paper. I received an email on that same day, on the 29th of January, in which the defense proposed meetings on facts and law that we could agree on. He suggested a few days. The first day, I believe, is the 3rd of February, if I'm not mistaken. And the prosecution will be very happy to meet on that particular day, the first day available to the defense, this Wednesday, to discuss points of facts and law. However, in this regard, I would like to propose that we focus on the document that we produce for one simple reason. We simply believe that in a clear and detailed fashion, it simply reflects all the points that we should discuss. Of course, without prejudice to the outcome of these discussions, I believe that we should simply sit and go point by point, giving, of course, the defense later on some time to consult with the defendant about his position as to those facts. So this is the position of the prosecution. The earlier we clear this matter, the better for us, having in mind all the deadlines that we indicated at the outset of this session, dealing with the filing of the pretrial brief and also the commencement of the trial. Thank you very much.
Thank you, Mr. Prosecutor. Mr. Fanboni.
Yes, Your Honor, and I thank my learned counsel for making that document. The document is called Proposal for Agreement on Facts pursuant to Rule 95. And in that, most of it are, it's a list of facts, right, as they are proposed or not. And there is some very easy items. There is no trouble with that. But the point is the following, Your Honor, and that's why I think it is important that the prosecution, my learned counsel, and me will discuss this in depth, because I would not want to have a situation in which we are going to have a debate about a said or a proposed type of fact, which in fact we might dispute at all, because if you make a point of fact and you say, well, okay, this is a fact, and please put your position on it, or whether you agree with that fact or not, it's fine with me too. But I do not think, Your Honor, that it is so easy that we can agree on facts, on law. There is not even that's not even part of it yet, as far as I'm concerned. Whether there is a internal conflict, or whether there is whether people can be conceived as member or non-members of the KLA, or and so on. So this kind of thing, I think we will need, and that's what I asked my learned friend too. Probably we will need to have some clarification about what we mean with that fact. In order, Your Honor, what is that serves the efficiency of the trial? Why? Because at some point when we say, okay, we agree on that point, then still the panel can say, well, we have our own position, and we can say, well, we want to hear about this or that point. But I think nevertheless it is important that we don't get into a debate and say, well, you know, it's what the parties have agreed upon, so therefore we can say that is a fact. That is not the case, and that is why I think the document needs a little bit more time for us to discuss about it, and then say, okay, this is what we mean with it, and that is the position of the SPO, fine, but we can either say, I simply dispute it, but the defense will not say, well, this is our position on that issue. That is, as part of the defense in itself, a part what we will use in the defense. So I'm not sure whether I'm clear or not, but let's have that conversation. I proposed a number of dates. I think it is important that in that conversation we first clarify what we mean with something, and then say, okay, we believe it is that way, and whether the defense or not agrees on it will be said in that document. Disagree or agree on it, but I would not want to have a situation in which the defense or the prosecution can rely on something and say, oh, but you know, let's not discuss that because we have agreed on it. So, you know, the court has further nothing to do on that issue. No, I think that for the benefit of this trial, it is important to see whether facts are indeed facts as they are proposed. So that is why I think we need to sit down and have clarification about that. There's a number of issues that need no clarification. The birth date of my client is something that needs no clarification. It's probably not even in discussion. But other points, whether the KLA is such or such organization, whether the KLA gets his orders from that or that group of people, whether those people, whether Mr. X or Y is indeed part of the general staff or not. Some issues like that can be disputed. Whether a particular brigade is operating or in fact actually operating in a particular area is a factual matter that I think we need to have clarification in order to avoid that we say, okay, we agree on that, and then the point cannot further be discussed. So that is the intention that I had in my email to my learned counsel, that we need to sit down on that. And I think if we work hard on it together, I think then that could be within a month's time or so completed. My personal estimate was that I would strive to get this document done within the end of the month, provided, I say that again, that I would have it being able to discuss with my client. The document is in English. It takes time to go through it. If I have an Albanian version of it, it makes it easier for me to discuss it with him, and it's more efficient. So my idea was to have it done within a month of time, but I say it again, if I have been able to discuss it completely with my client. That is obviously an important matter. That is my submission, Your Honor.
Thank you, Mr. Van Bonnet. My idea was also to have it done in a month's time, but starting from the last status conference, so I would have hoped that this would have been done by now. But I'm glad at least that you have started the discussions on this. Mr. Prosecutor, do you want to reply? And also on the proposed time frame for the discussions, which would be a month from now. So let's say the end of February. Does it seem like a reasonable timeline?
Your Honor, if I may address these points. So I think that this process is sounding much more complicated than it is, in fact. We are proposing facts. If the facts are agreed, in principle, they'll be taken off the table for trial. If defense counsel doesn't want to agree to the facts, that's fine. We don't need to have agreement, and we'll litigate them at trial. And so the description of prolonged conversations about these facts or debates, I think, is misplaced, and this should not be a place where we're going to see reasons for further delay of these proceedings. We have proposed facts. We're happy to discuss them. Mr. Van Bonnet can arrange for them to be translated if necessary, or have an interpreter with his client. But we would expect that this could be concluded within a matter of weeks. If it takes a month, that's fine, because there are other things that are going on. But it really should not take longer than that, and it is a very simple, straightforward procedure. If I may, while I'm standing, Your Honor, I would like to return to the matter of the investigations and the trial date to make clear the position of our office. The request for continued investigations until August is, in our view, extraordinary. This case has been charged for 4 months now. When it was charged, the defense had clear notice of what the case was about, and has had 4 months to conduct investigations, and it's my understanding that those investigations have been underway. To request an additional 6 months when it's been represented to us that an alibi defense can be resolved in 2 months seems out of proportion to what this case is. Let's remember that this case is very narrow, very specific. It takes place over approximately 2-3 week period. The events are very circumscribed and specific. We would expect, and I know Mr. Van Bonne has said that it's up to the defense to decide how long the investigations takes. Well, it is not up to the defense to decide that. It's up to Your Honor. And Your Honor should be making those decisions and will be making those decisions based on, obviously, the interests of the accused who's been held detained and by decision of Your Honor, but also the interests of victims and the public to have this case expeditiously resolved. So we would urge the court, we understand that the defense needs time to investigate. They should have time to investigate. We want this case to be properly litigated, properly defended. That is in our interest as well. However, dragging this out until August seems, on the facts and what is required by this case, to be truly unwarranted. And so we would urge a much more circumscribed period of time and urge that that be set as soon as possible by Your Honor so that we have clear direction and guidance of this case, because our concern is that this case, if that's not done, this case will drift, and that will not be in anybody's interest. So we would ask that this be addressed and that a reasonable time for defense investigations be provided. Thank you.
Thank you, Mr. Prosecutor. Mr. Van Bonne?
No, Your Honor, the issue on the point of facts is more complicated because it also has implications for the witnesses that we are going to interview. If we are simply going to say we dispute about something, then that does not help actually the case of the defense. In fact, when the position of the SBO is regarding the fact that there is a kind of safe house or a detention center or a detention camp in a particular area, which is run by a particular unit, then I think that is a question not only for debate. It's also a question for the defense whether we are able to identify witnesses who can actually argue that is not the case at all. Yeah? We can maybe say there is an existence of a school in Salih, or there is an existence of a house in Salih, but the actual representation of what that house is, or what the status is, or the qualification of that house has implications for the defense regarding their position on it. And I do not want to argue here in court anything without being able to rely on it through witnesses. And that's why I say we are busy to find the witnesses regarding many factual issues which can in fact say something for the defendant and say something also about the facts, whether those facts are facts or whether those facts are not facts as they are presented, especially in the confirmed indictment, whether that is the case or not. So that is obviously up to the trial chamber at some point to make that determination. But I think it is important for the defense that we are able to get time in order to get there. It will also speed up the trial, make it simple, make it more simple in order to make determinations. So that's why I think it's more complicated than it would initially look like.
Thank you, Mr. Van Bonne. Regarding this point, you are under no obligation to agree with anything. The defense is not obliged to agree with the facts. That's really the first point. The second point is that this is not the moment to debate about all the facts. It will be the trial that is aimed at that. So if you're not sure about certain facts, if you haven't been able to have sufficient clarification, you just don't agree with the facts. It's as simple as that. The agreement on law and facts is just aimed at speeding up the proceedings and not being obliged to litigate matters that do not need to be litigated in trial. But I understand your point, and if you hadn't had clarification on the point, the response is very simple. Then there is just no agreement. And when you say there's no agreement at this stage, it doesn't mean that your client will be absolutely litigating this matter with you in the trial. It just means that at this stage of the proceeding, you're not in a state where you can agree on the facts. So I think we shouldn't see this agreement as basically an obligation on you at this stage and an obligation to know all the details of the fact, because if not, we would do a trial within the pretrial phase and we would have to go into the details of each piece of evidence.
May I ask, Your Honor, words are important, and the question is whether you agree on the fact. That implies that that is a fact, and that is exactly what I'm trying to say. Whether that is a fact or not needs to be determined, and we will have that is a fact that might need to be proved by the prosecution in order to do that, in order to state that and make it a fact. Otherwise, we say, well, the defense disagrees with the fact. Please have them have their position on that fact. Well, no, first, I think it is up to the prosecution in order, when they make a determination about a particular fact, that they are able to give grounds for that. And saying, do you agree on that fact, implies rather that it is a fact, rather than that is remains to be seen whether it is a fact. That is what I'm trying to say, Your Honor, and that's why I think it is useful for me and my learned counsel to have that clarification, because then when we are able to agree on issues, then that makes it much easier. And then we can also say, well, okay, this is how we both view that particular fact and that particular issue. Okay, that remains undisputed. We don't need to litigate that.
Thank you, Mr. Fonbonnet. Can the party agree to engage in discussions very soon, especially since we have a proposal for this week? And can the party agree to finish these discussions on agreements on law and facts by the end of February? Mr. Prosecution.
If possible, we would like to make it earlier. As I said at the beginning, the first day stipulated by the defense was this Wednesday, actually. So we'd be very happy to sit together and clarify any unclear point that there might be in this document. And if the defense counsel, if the defense does not agree with something, let's go to trial and litigate the points. And let's agree on whatever we can agree just to clear the path for trial. So I would suggest this Wednesday as the first day proposed by the defense. Thank you.
Yes, Your Honor, I proposed in total four sessions, and I said at least we will probably need 2 sessions to meet for the minimum. But just to clarify, these are points of fact, not so much even points of law. Just to give that. And if there is another issue that we say, well, we are going to have a similar list on points of law, then you know, we need to discuss that. But regarding this document, I think we should be able to have it done within a month. I truly hope that the prosecution could provide me an Abelian version. It makes it much easier. My client can work for him on it himself, and the discussion that I have with him makes it much easier. It's hard work. I'll do my best to discuss all the topics with him, and that's why I also say if we have clarification on it, I can, of course, get that into the discussion that I have with my client, and then we can say, okay, that point is done, and it's off the table, so to speak. So that is what my proposition is.
Thank you, Mr. Fonbonnet. So I take it from our discussions that in a month from now, so Monday, 1st of March, the discussions will be finished on this topic. And whether there is agreement or not an agreement, this will be the deadline to reach any agreement on this topic.
It's fine, sir.
Nothing prevents you from reaching an agreement earlier. I would be most happy with that, but no later than the end of the month.
Yes, and Your Honor, it is the idea that when we have had this discussion and we have reached, we have completed this, that we submit it to you, or the SBO does. And that is the idea of the 1st of March.
Thank you. For the next point on the agenda, I'd like to turn to the defense first. Mr. Fonbonnet, do you envisage filing a pretrial brief and related material under Rule 95.5 of the rules? And if so, when do you expect to be in a position to submit such a filing? I would also like to hear from the parties about a proposed date for the transmission of the case file to the trial chamber, pursuant to Rule 98.1 of the rules. This is, in fact, follow-up to the discussions we've already started, but I would really like the defense to already mention to the court when it would be ready to move to the trial phase. Mr. Fonbonnet.
The first point, Your Honor, whether we are going to file a pretrial brief or not, I think that will be after the completion of the defense investigation. That will probably be the moment, and when the case of the defense starts. Before that time, there will be a pretrial brief. Let me see. Let me check for a moment, sorry, Your Honor. When it comes to a moment in time on which we would need to start the trial, yeah, I don't think, Your Honor, I have a clear date in mind. As I say, it is obviously that the defense needs more time to complete its investigation. I think it would be useful to start the trial if we have completed the investigation. And in my opinion, and considering the amount of witnesses that we envisage, I'd say yeah, somewhere in July or that time frame would be probably. We will not have completely completed the investigations at that time, but that is the estimate, I would say.
Thank you, Mr. Fonbonnet. Mr. Prosecutor.
Your Honor, since I started on this point, I'll continue. I'm not going to repeat myself, but we've made our position clear. We think there's been a lot of time for investigation and that the case should be transmitted to the trial panel already as early as March. If Your Honor is minded to provide more time to the defense for further investigation and delay the transmission of the trial panel, we would just ask that that be circumscribed. Thank you.
And once again, I reiterate, Your Honor, that the prosecution has had years to prepare their case, and we are under a lot of pressure in order now to file something quickly or to have this go on forward, and then things are simply not in balance. So I therefore want to stress how important it is that the defense gets the time that it needs, and in order to get the investigations done. Thank you very much.
If I may briefly, Your Honor, I'm afraid that's a false argument. We've not had years, we've been working for years, but we've been working on lots of cases, not just this one, and our obligation is very different to the obligation of the defense. We have to make a case and build a case and prove it beyond reasonable doubt, and bring the charges with that in mind. The defense, by contrast, is presented with a circumscribed case which is clearly laid out in an indictment and confirmation decision, provided with the disclosure that it needs to answer. And of course, it needs, again, the defense needs to have adequate time to prepare and to investigate. That is essential to this process. But it is in no way comparable to what the prosecution has had to do, and can't be measured in any way in comparison. And again, given the circumscribed nature of this case, the narrow nature and the information that's been provided, it's our view that we should be moving to trial relatively soon. Thank you.
Mr. Van Bonnet, and just before you take the floor, you've already had 4 months, and I've asked in every scheduling order of every status conference if you had a defense of alibi. And I don't think it takes 9 months to basically be in a state to finish investigations on this. So I perfectly understand that you need time for your investigations, but they also need to be reasonable compared to the size and the scope of the case. You have the floor.
Well, I think the scope of the case is much larger than people might want to present here, because I think actually that whatever is in the confirmed indictment, there's a lot to litigate about. And therefore, the clear-cut case and the narrow-down case, I disagree with that, because there's a lot of points of fact and a lot of points of law that we want to dispute, and disputing is something with words makes no sense. In order to have something well-funded and well-founded, you need to be able to rely on witnesses that can say something about that fact. In order to find those, it's quite a task, Your Honor. And the prosecution has always much more means than the defense has, and that the best means that we have is to give us time in order to prepare our case. That is the only way how you can get things into balance. Otherwise, we are at some point in time being confronted with the fact that, oh yeah, you know, we found this or that witness. We would like to hear them in that case regarding that and that point. Makes no sense. It only will delay the case in that sense, and I don't think it would be useful.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, do you want to add anything on?
And nothing further, Your Honor.
Next, would either of the parties would like to raise any point that has not yet been dealt with? And I remind the parties to give prior notice should any submission require the disclosure of confidential information. Mr. Prosecutor, is there anything else you would like to raise?
No, Your Honor, we don't have any points. Thank you.
Mr. Van Bonnet?
There is an issue of a third party involved that makes it very complicated for the defense to operate, and that has been taking a long time, too long time. And I truly hope that during this month there will be, with that third party, a solid discussion in which the defense can move forward. And that has been one of the issues that has been difficult in this case for the defense. I do not want to I remain a little bit vague, Your Honor, but I do not want to get very specific on the issue, but I can reassure you that it has been making things rather complicated.
Thank you,
And
Mr.
also the reason, Your Honor, that in the beginning of this case, the defense was simply unable to move forward.
Thank you, Mr. Fonbonnet. Mr. Prosecutor?
Your Honor, the defense counsel has been quite cryptic about what he's just said, but it raises some concerns if there are individuals or organizations that are impinging the work of the defense. That is something that, in our view, should be brought to the attention of the court in a more clear, direct way and as quickly as possible, because we certainly do not want to get in a situation where there is the defense's ability to operate is compromised. I, of course, leave it to the judgment of defense counsel, but I would just urge that that be a matter that is raised sooner rather than later. If it is, in fact, somehow impinging by whatever means the proper functioning of the defense.
Mr. Fonbonnet?
Well, as I say, Your Honor, I probably have more clarity on that in this month, actually, because there is a clear indication for me that that issue will be resolved.
Do you need to brief me on this issue ex parte?
And in closed session, I take it.
And in closed session?
I think it's useful, yes, Your Honor.
Or do you want to do it in writing?
No, I can bring it to. I can bring up the issue.
Then we will then probably have to break for 10-15 minutes to have this ex parte session now, but is it possible for the prosecution if we reconvene briefly for the end of the status conference after this ex parte session? Is it possible on the prosecution side?
Yes, absolutely.
Then, Mr. Fonbonnet, we're going to reconvene in 12 minutes at 12:30 for an ex parte session, the time you will need for this, and then we will reconvene later with the prosecution to finish this status conference. The hearing is adjourned.
All rise. All rise. Please be seated.
We are back in public session. For the end of this status conference, let me first add the parties if they have anything else to add to the previous item on the agenda. Mr. Prosecutor.
No, Your Honor, we have nothing else to add.
Thank you, Mr. Prosecutor. Mr. Fonboni.
No, Your Honor, not from the side of defense. Thank you very much.
Thank you, Mr. Fonboni. Before we move to the date of the next status conference, I would like to move to private session very briefly to discuss with the parties about a recent filing. Madam Court Officer, can you let me know when we are in private session?
We're back in open session, Your Honor.
Thank you, Madam Court Officer. Mr. Prosecutor, do you have any submissions on the date of the next status conference in this case?
Your Honor, we don't have any preference. The only remark I can make is that, as we indicated before during this session several times, we'll be very happy to finalize pre-trial process as quickly as possible. On our part, we don't need any status conference for now. Everything for us is clear. If Your Honor, however, or the defense requires any status conference, so let's do it perhaps at the end of February, not earlier than that. Thank you.
Thank you, Mr. Prosecutor. Mr. Fonboni, on the date of next status conference.
I would say in 2 months, Your Honor, simply because I think at that point I can also give a clear picture on how far the investigation is, and whether we maybe even earlier date for the start of the trial phase. Thank you very much.
Thank you, Mr. Fonboni. This concludes today's hearing. I thank the party and the registry for their attendance. I also thank the interpreters, stenographers, audiovisual technician, and security personnel for their attendance. The hearing is adjourned.
All rise.